I'd like to now call the meeting of the Planning Commission to order. This is a continuation of our June 3rd meeting, again for the application of the town of Trapp and Trapp East Holdings. Remind everybody that we are not taking any additional public comment, but what I would like to do at the beginning of the meeting to see if any of the commission members have any either legal questions for Tony or technical questions for Ray Clark, given the information that we've been presented. We've had a mountain of it. It's taken a while to get through it, but I know I have a few questions. So anyway, at this point, I would ask Ray if he would mind coming forward, and we can start. Bill, are you on the phone?
I am, thanks, Chip.
Okay, great. Bill, if you want, we could start with you. We have Ray and we have Tony with us. If you have any concerns or questions, for them, we'll go forward. So.
Well, I'll ask Ray a question I think that's all on mine, and that we have the letter that you wrote in the comments on the application from November 19th, as well as your comments were incorporated in Corey Pack's letter to the MDE. And the question is, have those issues been resolved at present?
At this time, Bill, the county has not received any response to any of the comments that were generated from the public hearing or written comments that I think were due to MDE on January 20th. So at this point in time, we have not received any response to those comments. I'm sorry, Bill, I'm sorry, the mic was off. The county has not received any comments associated from, I guess, what our letters. It's the same time from the public hearing that was held back in November. At the same time, written comments were due into MDE on January 20th, and MDE has not responded to our comments or anyone else's comments at this time.
Thank you, Ray.
So, Ray, while we're on this, I have a copy of that letter in front of me, and this brings up a little bit of concern for me. In other words, you questioned some of the information in that permit. So, if you could comment on some of those and help us. Your first thing, you stated that the application was incomplete and inadequate.
Correct.
Could you address that?
Yes. Based upon the application, one of the things that was required was a nutrient management plan that would be submitted as part of the application. There was no nutrient management plan submitted as part of that application. At the same time, I think the other question, was, related to that. There were some, I guess, issues associated with the application. One was that the president of the town council at the time was Cheryl Lewis. That was still in the application. So ultimately it was a recycled application that had information that was 10 years ago versus current information. So there were some issues there as well. And I think on top of those, a couple other questions that were being raised with MDE was pretty much, I think, associated with, one, without the nutrient management plan, we had no idea what the crops would be associated with that. And I think at the same time, I think some of the questions we were raised, or some of the questions you probably have, was storage requirements, 60 days versus 90 days. At the same time, I think we were, had some conversations with MDE about the overall process, especially for amending the common water sewer plan. And it was a little frustrating for us that when we were talking with MDE, their position is that they considered everything within the town boundaries as being S1W. And they were basing that based upon the passage of time, which we took exception to. That we felt that this had to go through the common water sewer plan process, through the public process, and that ultimately my office has never received any documents from MDE indicating what the classification of the S2W2 for the lakeside development. So usually when we submit a resolution that the Planning Commission as well as the County Council has voted to approve, we submit that to MDE. MDE then basically has up to 90 days. They review that with the Maryland Department of Planning. They then forward back a letter saying that that is approved. So typically, any application that Talbot County receives for a comp water sewer plant is pending approval of MDE. So we can't really say that's approved until MDE has reviewed it and approved it. So in the case of the town tract, we had nothing in our files indicating there was an S1W1 approval for the lakeside development.
Chip, can each one of these, since it's so involved, can we take each one of these comments and then if we have questions as commissioners, ask the questions instead of going through it all? And
Absolutely.
okay.
Yeah.
A question on,
Speaking to
a question on the nutrient management plan, and this is just for my knowledge. So with these nutrient management plans, so now we know that they're not going to be using those spray fields for 1 to 2 years or some extended amount of time. They're just going to be sending the effluent into the town of tract. What is the requirements for that nutrient management plan in those fields for that situation? Are they going to give you like a 3 to 4 year nutrient management plan or cropping plan? Or this is a very unique situation. So I'm not trying to throw a ringer in it. I'm just saying, in this unique situation, we know they're not going to be using those spray fields for an extended period of time. When does the nutrient management plan become a necessity, and when do they submit it? Because right now, I mean, it's just either a crop field or grassland.
Right.
And how long, I mean, how many years or how much time frame does that nutrient management plan need to cover? Because, like, I'm foggy about that and don't understand what is needed to put into this plan.
Right. My understanding with NDE under the permit is that they're requiring now within 6 months of spray irrigation that the nutrient management plan be submitted. I think one of the arguments that we have all been trying to make is that at a bare minimum there should be a draft management plan at least presented to show what kind of crops might be used and then ultimately how that how those crops be laid out.
So in your notes you said the nutrient management plan is missing.
Correct.
Could it not be missing? I
Well,
mean, if they don't plan to use that spray field for 6 months, could it also not be missing?
Well, I think one of the things that I would say is when this was originally coming out back in, let's say 2008-ish, if I'm not mistaken, when they first came out, they did have a meeting, and at that meeting, MDE highlighted that the nutrient management plan could consist of crops and/or trees. So the question would be, okay, what are you proposing to do here? There's been no discussion on that as whether they're proposing crops or trees. And I think the other component would be is what is the current nutrient management plan today? If they've got crops out there, the farmer should have a nutrient management plan for those crops today.
In my opinion, we just need to be very clear with the applicant and in this process. I have a note that says that the nutrient management plan is missing, and we have public comment that says it's not needed until they plan to use the spray irrigation 6 months prior to using the spray irrigation. If we want more than that, then in my opinion, we need to clarify, because I would like to see, personally, I would like to see their 3-year plan of nutrient management plan. What they're going to do in the short term on those fields, how they're going to manage it, what they're going to do when they're about to start using the spray irrigation field, what they're going to do when they're barely running the spray irrigation field, and what they're going to be doing when they're running it at full tilt. That's what Paul Spees would like to see. If that's not a requirement, then there's a lot of things in life I'd like, I'm probably not going to get. But we need to be very clear with the applicant about what we require, and then say something's not there. Well, if it's not required till 6 months prior to starting the spray irrigation, I'm guessing 99% of applicants aren't going to turn it in until 7 months and 20 in 1 day, and they're going to make the deadline. So that's my only comment. But I do think for this process and for us all to feel more comfortable with this project moving forward, going above and beyond what we're requiring it would be helpful.
May I actually comment on that particular topic as well? I'm really confused. I mean, I've been poring over documents, I'm really confused. I found this online. This is an application for state groundwater discharge permit for domestic wastewater. This is the instructions. And on page 2, it says, asterisk land application method of wastewater discharge. It's required to be submitted with the application. Maybe, Mr. Clark, you could say if I'm looking at the correct application. And I mean, it seems like it's a...
This is Bill, I can't hear Lisa.
Oh, sorry. Sorry, Bill. I'm just really confused because I just handed Ray a copy of the application, and the application with asterisks, the requirement that a nutrient management plan be submitted with the application.
And again, this is the application, and I think that's one of the issues that we were running into. I would also point out one of the things that we kind of have a disconnect here in some respects, that right now we're looking at the comp water and sewer plan. We're amending the comp water and sewer plan. At the same time, what's also happening is that the applicant is moving forward with their discharge permit. So there's kind of two things happening at the same time here. With the comp water and sewer plan, typically like the comp water and sewer plan, what would happen is it's amended, we move into design phases and whatnot, and then ultimately a lot of what's happening with the permit applications is coming after the comp water and sewer plan's been amended. So we're kind of in a unique scenario here where we've got two things happening at the same time. We actually have the comp water and sewer plan trying to be amended at the same time the applicant, the town, and the developer are trying to move forward with their discharge permit for their wastewater system. So that's one of the things happening that's kind of unique. But you are correct. I think that's one of the issues that we felt is that there was no nutrient management plan submitted. So it was difficult for us to determine what's being proposed out there. I mean, and at the same time, I know what the questions popped up with the Planning Commission is that if you're treating it to a higher level, let's say ENR level, which is 3 milligrams per liter or less of total nitrogen, now you're potentially in a position, because under MDE, they like 8 milligrams per liter. Will you be adding nitrogen now to offset that lost nitrogen that you have that's being pulled out of the wastewater treatment process? So those are things I think for us, it would have been nice to have.
But again, in the near term, their nutrient management plan is we're sending it to trap wastewater. They're not a generator of nutrients in the near term.
And I believe that's also part of the amendment is to go ahead and now move that to the trap plant for the first phases, possibly.
So again, we just need, so in the short term, they're not a generator of nutrients. So they're not required to have a nutrient management plan.
As it relates to the wastewater treatment plant, correct?
So they need a nutrient management plan 6 months prior to becoming a generator of nutrients that's field applied. Correct?
Correct.
I'm on the right.
Correct.
So in the short term, in this application process, what we're voting on is the amendment that says they're going to be sending nutrients to the trap wastewater treatment facility. That's the amendment we're voting on the S1W1, correct?
Right now, the way I think Amendment 1 identifies that the wastewater will either go to the what they call Phase 1A, which is the new wastewater treatment plant, or could be going to the the existing trap wastewater treatment plant until things can progress to the new treatment plant.
Okay.
So, but again,
I think I'm clear.
okay.
So my next question would be for Tony. So Tony, as a planning commission, are we getting ahead of ourselves when we are delving into MDE's permit and what it entails as opposed to the overall comprehensive water and sewer plan?
First, let me just ask, do we want to do a closed session for legal advice where I can provide legal advice to the commission? Do you want to do the technical questions with Ray and then do a closed session for legal advice?
I think Chip's question is pertinent to get answered, because if it's not, we could go through an hour of Ray answering it, and then you tell us that it's not pertinent, would be kind of, in my mind, a way. So I would think to have a...
Okay, I'll try to balance things then, and just rather than trying to apply the law to the facts, which would be sort of more legal advice, I'll just try to say what the statute says. So for the Planning Commission, the requirement to certify consistency is in the Environment Article, Section 9506, and that says that the county planning agency shall certify consistency with the county comprehensive plan. And then you have, in the land use article, it talks about the factors that are to be considered when you're looking at consistency. And that's what, at our last meeting that we had, that's what Mr. Council went through and the commission went through, are all of those factors. So that's really what's before the commission. We have a comp water and sewer plan amendment, including as amended by Amendment 1. And then you've got the 2016, the most recent county comprehensive plan. So the charge is to look at those two proposals and to figure out, is the proposed comp water and sewer plan amendment consistent with the county 2016 comprehensive plan? So take from that what you will, but the issues of the nutrient management plan, what MDE requires in its application for a discharge permit, I'll let you draw your own conclusions about that, unless you want me to delve into it further in a legal advice session. But Mr. Clark also pointed out that under the state law, you would typically have, it does seem, you would typically have a comp water and sewer plan amended first, and then you would have applications for a discharge permit and then a facilities permit. Because the relevant sections in the state law, in the code and in COMAR, talk about whether or not the discharge permit or the facilities permit are consistent with the county water and sewer plan. So it would make sense if MDE has to look at consistency with the county water and sewer plan, it would make sense that the county water and sewer plan is first amended, and then MDE looks at it and says, okay, is what they're proposing to do with their discharge or with their facility consistent with the county comprehensive water and sewer plan? So I think that's what he's pointing out. And here you do have this parallel track thing going on, and that has injected some confusion into the process. And it's hard to know what to attribute that parallel track to. I guess you could infer that they're trying to, just move ahead as quickly as possible by doing things on a parallel track. It's also possible that due to the history of the project, where they had previously gotten a discharge permit, it's just, given the long history of it, it could be that that's why we're dealing with this. But again, I'm not going to make any, I'll let you all draw your own conclusions about why, we are where we are with this.
Okay, another question for you, and again, if you think it should be closed session, but I'm okay with it. So I think both Ray and the applicant stated that as far as MDE is concerned, the entire property is that's one good. But can they move forward? In other words, I think the applicant stated they could move forward with or without the county's blessing at this point. Do you agree with that?
The applicant has indicated that, and Ray has indicated that he believes that MDE has a certain interpretation of the county comprehensive water and sewer plan. The county's position is that the comprehensive water and sewer plan needs to be amended first, and that the parcels in question would need to be designated S1, W1 in order for there to be a discharge permit or a facilities permit issued. So that's the county's view. The applicant and MDE may have their own interpretations, but the county's view is that we need to have an amendment to the county water and sewer plan to designate an area immediate priority status S1 before a discharge permit is issued to connect, residential properties or other properties to a sewer system.
Good, thank you. So I guess, Ray, back to you.
Mhm.
And I think, so the BNR treatment facility allows 8 milligrams per liter. The applicant has testified to the ENR system, which is 3. And I don't know how else to say this other than I'm okay with 3, I'm not okay with 8. So could you address that?
Sure thing. Let me just say that, as part of the application that you all are reviewing, Resolution 281 and Amendment 1, in those documents, the applicant has basically identified an ENR facility, which is 3 milligrams per liter total nitrogen and 0.3 milligrams per liter total phosphorus. The permit, the discharge permit, MDE typically will write the permit around a DNR facility, which will be 8 milligrams per liter of total nitrogen, and possibly, something higher on total phosphorus. I have to look at the permit on the total phosphorus. So in those scenarios, MDE in their position, in their, calculations, you want to call that, for spray irrigation, believe that the 8 milligrams per liter that's delivered from the wastewater treatment plant at that root zone will be net 0 for total nitrogen. That's something that we don't have MDE's calculations on, but that would have to be provided by MDE. But at the same time, the applicant, the contract, has proposed an ENR facility, which is 3 milligrams per liter for total nitrogen. And I think, as Tony pointed out, what we would probably, if the Resolution 281 and Amendment 1 were adopted, then what we could then go back to the state on is that the Compton Sewer Plant identifies an ENR facility. So that should be how the permit should be drafted, is based upon that ENR facility.
Sure, Paul?
So if this amendment passes, they're legally required to have an ENR system?
It's part of the plan. I think MDE, from what I've had some conversations with MDE related to this, they're a little reluctant to utilize a BNR technology, or I'm sorry, an ENR permit requirement for spray irrigation, because that would establish a precedent for spray irrigation that could be utilized elsewhere in the state.
I guess what Chip needs an answer to is, he's not okay with it, he's not okay with 8, but he's okay with 3. So we need to know, by moving forward and passing this amendment,
Passing
that
the amendment
it
would be,
requires the 3.
it would be we would have a better argument with MDE of pushing 3 milligrams per liter.
A better argument, or it would require 3?
I think at this point in time, the applicant has also indicated that they were willing to move forward with the ENR facility. So I would say at this point, 3 milligrams per liter or ENR would be the way to go.
Could I ask a question? What assurances do we have other than people nodding their heads? Do we have something in writing?
One of the things we do have is that they've submitted their application within the Compton Sewer Plant with ENR. So that has been identified within the Compton Sewer
Is
Plant.
this amendment actually an assurance in your mind?
That's basically all we have.
Okay, then,
We are-
okay, that's basically all we have. So here I'm seeing a may, not a shall, but a may. That to me is not an assurance. Could you help to interpret this for me, Mr. Clark? This is on page 7 of the green document I referred to, because it's the only green document in our packet. The proposed amendment number 1 to resolution 281. I mean, in good conscience, I see no assurances, but anyway, let me just count the lines down where I'm starting. And I'll count every line that has letters on it. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. In the 12th line, the underlined portion on page 7, proposed amendment 1 to resolution 281 dated February 11th, 2020. The initial treatment and disposal capacity, I'm sorry, I should have started it. Next line. Startup wastewater treatment for the Lakeside project may be provided by a modular ENRB, MBR, WWTP, capable of operating at the initial development flow rates, or by a direct connection to the existing trapped wastewater system. In reading this, I have no assurances, that this is going to be what they're actually going to be doing. So how can I assure consistency if I have no assurances of what they're going to be doing?
That's, I mean, as far as the drafting of the documents has been in conjunction with the town draft as well as the developer. So the question would be, if they were willing to change that from may to a shall, that would be the question that would be good with that draft.
And there's an either or there. Let me, on further note, they may connect to the existing town of trapped wastewater system. When would they even switch over? We have no assurances. And could the current wastewater treatment plant even handle this? I understand that there may have been a grant application to connect 11 homes in Trapp, and it was recently turned down because of something. Can you maybe go into that a little bit more for me?
Well, first off, yeah, I think the Howe Point, there were 11 properties on Howe Point Road. The county basically worked with the town of Trapp to amend the common water sewer plan to bring those 11 properties, they're currently on water from the town of Trapp, bring those 11 properties into the sewer system. My understanding, have to come back to the town, but my understanding is the wastewater treatment plant for the town of Trapp has a hydraulic design of 200,000 gallons a day. They're currently doing they have about 100,000 gallons. So they have 50,000 or 50% capacity remaining at their wastewater treatment plant. I believe in the early 2000s, the Trapp wastewater treatment plant was upgraded with what they call BioLac, which is a BNR technology. That BioLac system was supposed to have met 8 milligrams per liter total nitrogen and possibly 2 milligrams per liter total phosphorus. At that point in time, when we were moving forward with the application to amend the common water sewer plant for the 11 properties on Howe Point Road, the hope is that we could then turn around once that was amended to the state of Maryland and say, okay, now we'd like to go ahead and get BRF money, Bay Restoration Funds funding or money to assist those property owners in connecting to the town wastewater system. At that point in time, MDE said that they did not qualify for BRF funds because their plant was not consistently meeting the BNR requirements through their facility.
Okay, so fast forward, we hook up the first 87 homes from the Trapp East development to the plant as this indicates may happen. Which, by the way, I was pretty convinced that we were going with the ENR technology with the 3 milligrams of the last 3 meetings we've had. But besides that, now we're hooking up to the local plant, which is not meeting standards. So first, we have no assurances that they're going to use ENR. And second of all, they're hooking up to an existing plant. We don't even know when they're going to switch over. And a plant that's been turned down apparently for not meeting standards.
My understanding is the town is also pursuing or having a preliminary engineering report completed to actually upgrade their existing wastewater treatment plant with ENR technologies, but I don't know the time frame. That's the more question for the town of Trapp. I very quickly would just highlight that when it comes to, I guess, the management of the town of Trapp's water and wastewater system, typically they're referred to as a controlling authority. The Department of Public Works for the Talbot County, we're the controlling authority for St. Michael's and our facilities. MDE basically is the regulator, and so ultimately they're the ones that are issuing the permits, they're overseeing and managing the permits. So in those scenarios, it's basically going to be the town of Trapp meeting the requirements that are established by MDE.
Tony, at this point, would you like to weigh in on Amendment 1, the may instead of the shall, and then the applicant says they have applied for an ER system, so does that have teeth at this point in your?
My understanding of the may of that sentence is that the town wants to keep open the option of serving the initial phase of the development either by a new facility that they construct pursuant to the permits that they're seeking from MDE or from the existing town of Trap wastewater system. So that's what my understanding with the may is. So if it seems that if this were approved, this amendment were approved, then if they decided to do the first phase of the development with the existing trap facility, I'm not certain what additional approvals from MDE would be needed at that stage, because the permits that they're applying for from MDE right now pertain to the construction of a new facility. So if they decided to exercise that clause, the may clause, and go with the existing system, the following sentence talks about connection to the existing town of Trap wastewater system is subject to the approval of the town of Trap, available wastewater capacity, and adequate access to the collection system. So Trap is essentially, through this, saying these conditions would have to be met in order for us to allow that initial connection. The initial phase of the project is discussed a little bit in the preceding sentences, and it's talking about, it says phase 1, section 1 of the proposed lakeside project is expected to include approximately 84 family residential dwellings and a visitor and sales center, and it projects that the capacity required will be 30 to 40,000 gallons per day. So presumably, you know, and that's not binding language in the sense that it's basically saying that's the projected amount of homes in the initial phase will be 84 plus the sales center. So it's not saying that that's the absolute number, that's the projected number. And so if the town of Trap were to allow a connection to its current facility, based on that projection, they would need 40,000 gallons of free capacity. Ray has indicated that he believes that the facility has 50% capacity remaining. I think the facility is about a 200,000 gallon per day facility. So based on the current estimates, it would seem that they would have enough capacity to absorb that. But, you know, is the system operating up to MDE standards? You know, I can't answer that right now. Each, you know, they collect monitoring reports, I guess, each month, you know, that has the data for what sort of output the facility is doing. As Ms. Gezi has pointed out, there, I guess, were some concerns earlier related to bay restoration funding. So is there some uncertainty associated with that? I suppose you could draw that conclusion. However, that is an existing facility that's approved by MDE, and that appears to have, or there's a suggestion that it has sufficient capacity to accommodate the 30 to 40,000 gallons per day. So the alternative is the construction of a new facility, and I think that to get to the issues that have been raised about does this have teeth in terms of the discharge, the milligrams per liter, I think that you all would need to parse this language to decide whether is the language strong enough to say that this is the kind of facility, this is the only kind of facility that's envisioned as far as the new facility is concerned. How much is the door left open to some other kind of facility? It does clearly talk about, you know, an MBR, ENR wastewater treatment plant. There's not a discussion of another type of plant. And so, you know, the question that it seems that you're looking at is if this all passes and then MDE, you know, now has the amended comp water and sewer plan in front of it, and then they have this application for a discharge permit in front of them, and if there was some modification to the application, you know, how far could MDE go in allowing some sort of a change to the application? So I think Ray has said that the application is for an ENR system, which would be consistent with this amendment. But, you know, it becomes, once the comp water and sewer plan amendment is passed, if you're looking at the next step, the discharge permit, that becomes an MDE question. And it's up to them to decide whether that application is consistent with what the county has done in the comp water and sewer plan.
So Ray, so we do have, so will MDE have the ability to require 0.3 nitrogen, or will it, no matter what system they put in, their requirements are going to be the 0.8?
I think in my discussions, they're not going to change the permit. The permit will remain at 8. It will remain at 8 milligrams per liter. The factor, I think, is in the, you know, because Round Incorporated is looking at, the town, I think, is also looking at, by going ENR, they're protected for the future. So if the state were to ever change those discharge requirements on them, they already are meeting the best available technology. So, I mean, you know, if I were them, I would be doing the same strategy.
Yeah, so no matter what equipment, so no matter what equipment they put in, the MDE permit is going to be for 8 milligrams.
Right, I believe that is correct, yes. And I think the key is that permit, the MDE is going to set the line. They don't care if you're below that line. You know, they're going to say you've got to be at 8 milligrams per liter. If you decide to be lower or better treatment than that, that's up to you as the applicant.
So Ray, I referred to you as the expert. I'm also going to refer to you as the keeper of the gate. Are you comfortable with where MDE and the applicant are in regards to standard 6, land use protecting environmentally sensitive areas?
I mean, from my perspective, I think yes. The hardest part right now for us is we're trying to go through the comp water sewer plan process. I know there's a lot of concerns that have been raised by the applicants and outside the citizens. The one thing I think that's kind of unique about this whole overall application, and I think, you know, one of the things I just want to highlight that, you know, because I looked at it a little closer, you know, the question like 60-day storage, you know, that's been outlined. One of the things that I think that Ralph has identified is they're looking at 60-day storage, but in addition to the 60-day storage, they're also looking at 14 inches of rainfall, and they're looking at 3 feet of freeboard. Technically, I did a real quick calculation. By that volume, they actually had, if they were at the berm at the top of that spray irrigation, it had 245 days of storage.
Wow.
So from the storage perspective, they would have more than enough storage capacity. I know in MDE in the past, they don't like to see freeboard less than 12 inches.
Sure.
So I think they prefer 24 inches. So having 3 feet of freeboard is actually exceeding that 24 inches of freeboard requirement.
Excuse me, Mr. Clerk, could I just ask you, in your calculation, how much rainfall did you consider in that?
They have identified here 14 inches.
14 inches annually?
I think they're adding here 14 inches of rainfall, as if whatever that is, during that period of time. So that has been included in that volume of that. All they've done is they basically said that in their storage units, they've put in 14 inches of rainfall. So that volume for 14 inches is built into their total volume.
So is this over, at what period is this over?
This would basically, if you took the total volumes that they've identified and then divided that by their 540,000 gallons per day, that would then establish 245 days.
Okay, because online, you know, rain falls at 14 inches at, you know, different places, and we've had up to 90 inches, and how is that taken into consideration?
I think what you have to remember is this is going to be a dynamic scenario. So
Right.
effluence going into that pond, as it's collected in that pond, there could be rainfall. And then they'll spray irrigate when the temperatures or the weather is nice enough for them to spray irrigate with less, not strong winds. So it's always going to be going up and down for the lagoons. So I think if they were to get, let's say they got 14 inches in one day, that's more than enough capacity in there. But again, they're going to be spray irrigating.
So you're saying 14 inches in one day then? Okay, that's
I mean,
clear.
what they've done is they've taken the volume. They've added 14 inches of depth for rainfall.
I didn't mean to take you off track.
No.
We're good. Any more questions?
Ray, this is Bill.
Oh, yep.
Yes.
Yeah, can I ask something, right?
Yes.
I'm looking at the letter from Corey Pack, which is your words as part of the November 19th, and as an item 6 in there, and I just want to quote, as part of the permit review, MDE should consider the Bay TMDL and the John D. Hines and Associates Incorporated hydrological evaluation of the proposed spray site as it relates to urban stormwater runoff and the proposed spray irrigation to determine the impacts of the proposed development on the streams within the Chop Tank watershed. I just want to endorse that and say that it is clear we have no comeback from the Department of Environment on this issue. And I think it's extremely important.
Yes, I agree.
If I may, just to bring myself up to speed with what we've been talking about today, both from Ray and Tony, that if working backwards a little bit, so with the 14 inches of rainfall, if we get, by the time we have 14 inches of rainfall, they need to start spray irrigating to bring the level down. Is that correct?
Typically, what's going to happen, again, like I said, it's a dynamic scenario.
Sure.
That what's going to happen is that I don't believe the town trap is the operator of the facility is going to wait till the lagoons are full
Right.
before they spray irrigate. So typically, what's going to happen is they're going to let volumes build up into that spray lagoon. As those volumes build up, and the weather's nice like today, they'll be spray irrigating. And if I'm not mistaken, their permit's going to require them to put in as much as 1 inch a week out on the spray fields.
Okay.
So I don't think any operator other than, like I said, the biosolids facility, we are prohibited for spray irrigating, let's say from the months of December through February. We actually have, for our 20,000 gallon per day facility, we have over 2 million gallons of capacity because we hold everything for that period. And the reason we do that is that for us, we cannot spray irrigate unless there is vegetation on the ground because that is our nutrient uptake at that facility. I believe here with town trap, again, it'd be associated with their nutrient management plan, whatever the crops they're growing, they could spray irrigate. And MDE has allowed that as long as you have vegetation on the ground, that you can spray irrigate at any time of the year.
Okay.
So.
Okay. And then moving back, that we talked about much earlier in the meeting about the parallel tracks that we're on.
Mm-hmm.
I'm assuming we're somewhat on parallel tracks because this thing started years ago. Things got ahead, assumptions were made. But as of right now, if we pass this amendment, that then the tracks are no longer really parallel. They have to go to MDE for the permits moving forward, and that with 6 months or more before they want to start operating a plant that they build, assuming that they hook up to the trap facility to start with for the initial phases and the initial houses, they will have to have not only their application in for approval, but with that application, a nutrient management plan. And so at that time, if the nutrient management plan, which will have to state what crops will be planted and for whatever period of time the requirement is, before that has to be updated, MDE will look at that and certify whether or not that meets their requirements. And if it does not meet their requirements, they will deny the applications to move forward at that point.
As far as discharge permit, yes.
Okay.
And I think one of the things I would just also highlight for the Planning Commission as well is that the Hines report, which was actually given to us at the night of the public hearing that they had down in Town Trap, also identifies the MDR treatment system. So it has been identified in their hydrogeologic report of using the MDR as well. So I mean, it's they're this real intent of utilizing the MDR ENR technology for their treatment system.
Thank you.
Further questions for either Ray or Tony?
I have a question that may be applicable either to Ray or to Miguel or to Mary Kay. And in terms of the Planning Commission, are we looking at adequate facilities and how they help to protect what's demonstrated in the comprehensive plan to be sensitive areas? It's my understanding that, one area of testing for sensitive areas is the actual adequacy of that facility. And that's what we've been looking at, ENR versus the existing wastewater treatment plant, what technologies are going to be used. There's no assurances what's going to be used. So my question to Ray and Miguel, perhaps, only because Miguel has prepared many of these documents, is are we to be utilizing the test of adequacy of the facilities to determine consistency with the comprehensive plan?
There is no, so a lot of the policies that you're referring to, as well as text language in the comprehensive plan, is located in Chapter 6, which is the natural resources section. That section does point out there's the public wastewater systems that are not owned by Talbot County, but one of them being the town of Trapp. And there isn't a lot of specificity in that natural resources section related to the town of Trapp, other than pointing out its available capacity and then future demand projections for the capacity on that wastewater system that Trapp currently has. There is a reference in Chapter 6 about the lack of available capacity under the existing town of Trapp wastewater treatment plant as it's projected, I think to 2030, unless there is a proposed 540,000 gallon per day wastewater treatment plant upgrade and spray irrigation system, unless that's built to support the lakeside project. And then it talks a little bit about alternative wastewater disposal as an alternative to doing a point source outfall directly into a stream. That spray irrigation may be appropriate for larger public systems due to the ability to have nutrient uptake. But everything else from my reading of the comprehensive plan under Chapter 6, everything else really talks about, it does talk about impaired waters, but everything else really doesn't deal with what's happening inside of Trapp, but what's happening outside of Trapp, outside of the incorporated municipalities and in Talbot County. For instance, it talks about stream buffers in the critical area, for example, and it talks about stream buffers outside the critical area. We do have, for instance, in the zoning ordinance, stream protection buffers outside the critical area, intermittent and perennial streams, 50 feet and 100 feet respectively, but that's embedded in our zoning ordinance for Talbot County. That has no impact on the town of Trapp's any specific stream protection policies in their comprehensive plan or stream protection regulations in their zoning ordinance. And so to sum up my answer, there isn't a lot of specificity in Chapter 6 under natural resources that deals with the town of Trapp's wastewater treatment plant system.
To answer your question about adequate facilities, I would just note that at this point in time, I'm not aware of a consent order that has been imposed upon the existing wastewater treatment plant for the town of Trapp. At the same time, I am not aware of any prohibition for them not moving forward with any new development within the town of Trapp that would utilize that facility. That would actually come from NDE through their enforcement. If there were issues that said you were not allowed to do anything, if you would be prohibited from basically doing any new construction and connecting that to the treatment plant, NDE would have made that order.
And is historically MDE on top of that in other jurisdictions as well as ours, if those issues come up at a local level where they have the jurisdiction?
They would make that call,
And I'm just asking historically, have they made that call?
they have, yes. Sometimes it takes them a while to do so, but they have made those calls.
So in the meantime, runoff may occur?
Or I would probably say with this, with the facilities for the wastewater treatment plant, if they're not meeting the permit, that would be something that has to come through MDE. They have delegated authority from EPA. So if they're finding that there's that the town of Trafford has what they call significant notice of violations, then what would end up happening is MDE would say, okay, you've got to address that. And as part of that addressing of those issues, MDE would then issue a consent order to this town, and through that there would be, I guess, milestones that would have to be met within that consent order that would come through the AG's office. As it relates to stormwater, that stormwater actually would be something that would probably, as part of the development's concern, that would have to be incorporated as part of the town's review of the developer's stormwater management strategies, and then at that point, they'd be monitored at that point.
Thank you, Mr. Clark.
Further questions? Mr. Stranahan? Ms. Guzzi?
Are we going to go into session, closed door session?
If anybody feels the need to, they're more than welcome to make that motion. Questions?
Nothing further.
Mr. Boycourt, do you have any further questions for either Ray or Tony at this time?
No, I don't, and I thank Ray for being here this morning.
Sure.
Yes,
Yep,
thank you.
Thank you very much. Okay, so at this time, then, what's the pleasure of the group? If you want to go into executive session, now's the time to make that motion.
Yeah, I understand, yeah. I would like to have Mr. Cooper Smith respond to your question from earlier regarding, I'd like to get legal.
Okay. So it's my understanding that Commissioner Gezi is making a motion to go into executive session to consult with our attorney on legal matters at 5 minutes of 10.
Mr. Chairman, may I suggest that, given that we don't have phones now, we're not using phones in the room for our meeting, that we, when we go into executive session, that we actually leave the room, and I think there's adequate space out in the lobby to social distance and have executive session. I would ask anybody listening, either through live stream YouTube or on a WebEx call to just, if they want to wait, to please don't hang up or don't leave the live stream meeting, and we'll be back once executive session has ended.
Do we need a second and vote?
Here's a request from Bill, who's on the phone call. Could somebody, at the end of that executive session, just give me a synopsis by phone call?
Actually,
And I can give you another.
Actually, Bill, we have set up a separate call-in for executive session, so one of us will be, either you'll be able to call us or we'll connect you in.
Okay?
So this should hang up, is that correct?
Yep.
Yes, for you, yes. You'll call back in once we come back from executive session.
So there,
But right at the moment, what should I do?
So you can hang up now, and then we'll connect with you for executive session.
well, we still need a second and a vote.
I'll second that.
Okay, so we have a motion by Commissioner Gezi, a second by Commissioner Stranahan to go into executive session. Miguel, would you please call for the roll vote?
Sure. Mr. Boycourt?
Aye.
Mr. Stranahan?
Aye.
Ms. Gezi?
Aye.
Mr. Steves?
Aye.
And Mr. Council?
Aye.
Motion approved.
Mr. Boycourt, before you hang up, can you give me just the last two numbers of the number you want us to call? Because I have 4 numbers for you. So just give me the last two numbers and I'll.
Let me, 15679, sorry.
Okay. We'll contact you on
Thank
that.
you.
All right.
Stay with us, we will return shortly. At 10:26, we met with the attorney for matters of law and procedure as we move forward. So at this time, I would remind everybody that we did go through the 7 standards for the consistency with the comprehensive plan. And we will go through the commission one more time to make sure that everybody has had their concerns addressed, or again, if there are additional questions for staff or the attorney. So, yes, Ray?
Yeah, I just learned when you all were in your executive session that MDE is now incorporating the ENR facility into the permit. So
Okay.
I just wanted to let you know.
So to make the record clear, we just learned that MDE is incorporated the ENR process in their permit. Bill, are you back on? Did you hear that?
I did, thank you.
Yep. Okay.
Just
Very
a
good.
point of clarification, is that including the ENR into the application? Is that just the equipment or the flow rate or the nutrient load rate?
That's actually going to be the equipment. The MDR is an ENR. So what I understand, just learned from Ryan, is that the MDE is now incorporating the ENR technology into their discharge permit. So that's now part of the permit.
But the nitrogen and phosphorus loading will still remain the same
I'm
number?
assuming that if they're incorporating that, it would be that the 3 milligrams.
Okay, thank you.
Great. Okay.
And just for clarification, what does that mean? Can you just tell, is it from a timing perspective, when will the ENR equipment be put into use per what they've just added?
I think, with the permit, once the permit's been issued and it requires the ENR components, that when they're moving forward with their, let's say, construction, they've received their MDE construction permit to construct that wastewater treatment plant, that would be the time it would be required to go with the MDRs, with the ENR treatment. So it would be at that time of the issuance of the construction permit.
Yeah. Okay. Bill, questions at this time?
Not Ray, no, thank you.
Okay. Yep.
I have comment, well, I have a comment, you want to go forward with it?
Sure. Let's do everything at one time. Go ahead,
Okay,
Bill.
well,
Yep.
I don't want to rehash too much about where we stood last time, or where I stood last time. I think you want to recall that my objections to the amendment were twofold. One, environmentally, I thought that there was inadequate protection for the sensitive areas, not just of the Miles Creek headwaters, but also Trap Creek. But I also wanted, and most of our discussion this morning has been focusing on the MDE permit in terms of the environment, which that's my name and what I do. But the other issue that I want to bring us back to, is just briefly, is the ability for the county to exert some approval and control over what we intended to have in the comprehensive plan. That hasn't changed. Tony, I think, properly said this is a lot of different things now, but what hasn't changed in the comprehensive plan is the land use policies state that it says that support concentration of growth within the town and then incrementally within the growth areas adjacent to the town after annexation. The intent is to support the ordered expansion of the town. That remains. And I think that what has changed this morning, since I got the Ray Clark letters and the letter from Corey Pack to MDE, is it's sort of a greater discomfort with the fact that that the uncertainty with regard to giving, if we approve this amendment, approval of 2/3 of the proposed developments without any controls or checks and balances along the way on the part of the county, I think is incorrect or not advisable. And that's what the Public Works Advisory Board said very clearly, and that's what I read in the Ray Clark's letter to the MDE, letters to the county, and then those are included in MDE. The fact that MDE has not come back, Tony listed some possible reasons why that was the case, and I take that as evidence that if they're not forthcoming, that increases the uncertainty. So in that phase of uncertainty, I would propose that we find this not consistent with a comprehensive plan, if only to protect the county from these great uncertainties. I think that the ENR versus DNR, those are important issues, but they're down in the weeds as far as I'm concerned. This is a broad concern about the development and its impact on the sensitive areas, and it's a broad concern with regard to the development of this number, even if it's a 20-year process, on the county's infrastructure. So both of those, I think the county should not abrogate the responsibility for those responsibilities it has, and I think that for that reason I'm against this proposal, this amendment.
Thank you, Mr. Boycourt. Mr. Stranahan?
Just one quick question for the staff, referring back to the paperwork for a May 15th, 2020 meeting. Is there anything, additions, deletions, or any changes to your recommendation and the background information that you gave us at that time?
There is not.
Thank you, that's all.
Commissioner Gezzi?
Yes, not to get back in the weeds, but there's one, just if I didn't ask it, I would not go to sleep at night. And this is for Mr. Clark. Doing my due diligence, we've poured over documents in preparation for the last 4 meetings, and there's just a lot to take in. And I have very similar feelings as Mr. Boycourt. And details matter in this case because we're looking at consistency with a comprehensive plan. And to me, I just need to understand better. In the May 18th Public Works Advisory Board letter, to the Talbot County Council, they attach a memorandum, or perhaps this was, no, it looks like it was attached, that's how I received it, regarding another number of a daily maximum of 1.5 million gallons per day. And in the hydrogeological report, it bases all of its calculations on 2 numbers that President Pack notes in his January letter of being the hydrogeological report is utilizing a rainfall number that is not representative of our area. It's based on Salisbury numbers. But the second part of it is this 1.5 million gallons. The hydrogeological report uses the average as the maximum, and I believe incorrectly. The 540,000 gallons per day is an average number, not a maximum number, and that's what's pointed out in this May 18th memo. So, Mr. Clark, if you could just help me to understand, I mean, that's pretty huge because all the numbers are based on the 540 gallons per day as a, quote, maximum according to that report provided to the applicant. And it kind of throws, to me, it throws all the other numbers out the window.
Unfortunately, in wastewater, you design a system, and what you have is a peaking factor. So what would happen is you would have a daily average flow of 540,000 gallons a day, but then you would ultimately have, let's say, a daily or a peaking factor, a daily maximum of 1.5 million gallons a day. And part of that is like, to give you an example, the St. Michael's wastewater treatment plant. We have a hydraulic design flow rate of 660,000 gallons a day. Currently, we were discharging anywhere from 300 to 340,000 gallons a day on a daily average. There can be periods, let's say of a heavy wet weather event, that we could actually see our flow rates go to as much as 2 million gallons a day, or 1.5 million gallons a day. because we have what we call inflow and infiltration numbers coming in. So that's more of a peaking factor that would occur, again, on a daily maximum. So that's roughly about 3 times a peaking factor. But again, it's because of the dynamics. Sometimes you can have things happen that, you've got inflow coming in that you need to address or something of that nature. But 9 times out of 10, the daily average, and then ultimately from the permit perspective, there's going to be loading factors that you'll have to calculate. And then under those loading factors, whatever that, in this situation, the applicant or the operator would actually have to report what those loading factors are on their permit, and then assure compliance with those loading factors at the end of the year. So this is probably one of those, this is more of a peaking factor at that one day of a 3 times the daily average flow.
So you're not concerned about the number, and that there may be potential, especially if it went from 3 to 8 milligrams per liter, which is 2.4 or so times the nitrogen load. I'm just looking at nitrogen, not even phosphorus, which is actually, so you're not concerned that that will push the system beyond, and that there will be a lot of nitrogen load, additional nitrogen load on the soils.
Again, going back to like the same microsolar treatment plant, let's say in 2018, with the wettest year we had on record, we had 90 inches recorded at our Wastewater treatment facility. We saw an uptick on our daily average flows, but during dry weather events, we were, let's say, less than 300,000 gallons a day. During, let's say, a very wet weather event, we may see our flows up to 1.5 million gallons a day. What ended up happening over time, that averaged out to, let's say, maybe about 380 to 400,000 gallons a day for that year. At the same time, if we had a very wet month, it could have been that we might, I don't think we did, but we could have exceeded our loading factor for that month. But then it's through those other months that we brought those averages down, so we met permit on a loading perspective. But that typically treatment plants don't operate at, let's say, like us driving a car, we don't go 55 miles an hour when it's 55. We sometimes go a little higher, sometimes a little lower, depending upon the situations. It's kind of the same thing with a wastewater treatment plant. Flows are going to go up and down throughout a period of time.
Thank you for that.
Anything further, Commissioner Gizzard?
I'd just like to reiterate that while I think, the staff has pointed out many good reasons for consistency, that there are many areas that shed any doubt still for me. And as I've tried to understand those, I'm just not convinced that we're offering the protections. We're not being mindful of the sensitive areas in our area, as well as a major influx of growth in our area. And for that, I just find it very difficult to find that the proposal as presented and the uncertainties that it itself proposes. I'd love to see a revision to the MDE language, for instance, and the underlying edits to this particular amendment. I appreciate the explanations of staff to help me to understand these better, but I'm still just very unsettled that they don't completely answer the questions that would cause our inability to really protect the areas that we need to.
Thank you. Commissioner Spies?
Yeah, this is one of these difficult ones of being commissioner up here, where it crosses the line of personal preference and personal desire, and how this county is developed and move forward comes in direct conflict with what we're required to vote on. How we've set this up as the county and the state I believe that the project, not my personal favorite project, but how this project and this development has moved forward, and what we're tasked with on voting on a month ago, 2 weeks ago, and now today, has followed the requirements that we've set forward. Again, just for the record, we're voting on whether was this project designed right? Is it too big for the county, not too big for the county? We're voting on a time frame that in my mind has already been passed. We're voting on whether this should move from a S2W2 to an S1W1, which meaning it moves into a category where they plan to develop it in the next 5 years, a portion of it in the next 5 years. So in my mind,
Well, I can't hear you. Will you speak a little
yeah,
closer?
so basically the gist of it is that, through the multiple days of testimony, even with my uncomfort level, I think we've shown that it, in my opinion, it is consistent with the comprehensive plan, and that even though that we do have some concerns with permitting and other things, but the overall arching testimony for me shows that this resolution, or this amendment to Resolution 281, is consistent with our comprehensive plan.
Thank you, Commissioner Spees. The only additional comment, that I would make, again, I mentioned at our last meeting, I had friends, family that work, live, and play in the trap area. It's very important. Ray's answers to some of the questions we had this morning eased my mind considerably. I hope it did some others as well. When we just heard that the permit will go to an ENR technology instead of the BNR technology, that helps a lot. So I think, additionally, the comments that I've made along the way probably still stand. So if everybody is comfortable and felt that they've expressed their views, so forth and so on, we are probably ready to entertain a motion.
I'd like to make one more comment.
Sure.
That's okay.
Sure. Commissioner Boydcourt?
In my now consistent statement that this is not, in my opinion, consistent with the comprehensive plan, I want to emphasize that this is not because I think that the program should not go forth. The specific recommendation is that the program go forth with the ability of the county to provide checks and balances. So that's consistent with the Public Works Advisory Board position, it seems. So, yeah, I'm not saying that I'm against the program going forward, or the project going forward. I'm against having no control once if we happen to say this is consistent with the plan, which I think it's not. I think that's incorrect. I think that the county should maintain its control. So that's all.
Sure. Understood. Thank you, Commissioner Boydcourt. Commissioner Gesig?
And my level of discomfort is that I don't think we have adequate assurances that things are going to be done as possibly indicated, and that's my discomfort. Yes, control, I agree with Commissioner Boydcourt that control, and checks and balances along the way would be even better. But even with what we have, I don't have the confidence, the assurances that what's been presented, all of those pieces will take place to help us to protect the sensitive areas, aspects of the environment. And, this area is a remarkably special area, Talbot County. We have, just a wonderful, wonderful community and a very special place that I think in part is demonstrated in our ability to come together as a community and have such a low COVID impact, which is pretty amazing. We care about our community, and I want, to be in a position to have the assurances to say, that this is going to go forward with the standards that MDE has set, and yet I have so many questions regarding, will these pieces really be carried through? So, so that's my last comment.
Thank you. Mr. Stranahan?
I tend to parrot what Commissioner Speed said earlier. This is probably not my favorite project that could come before us, although it's been before the county for many, many years now. However, with the advent of this new amendment, and that is what our job is here today, I believe, is to certify this specific amendment with the compliance to our plan. I believe that it has. I agree with the concerns of Commissioner Gezzi and Commissioner Boycourt, but I don't believe that that is the issue in front of us today. I believe that we're beyond that, and that those specific concerns will be addressed by MDE moving into the next phase of things.
Thank you.
Chairman, I propose we make a recommendation to the county council that amendment number 1 to resolution 281 is consistent with the comprehensive plan based on the multiple days of testimony, mainly that on the June 3rd that we went through the 7 regulations to find something consistent with the comprehensive plan, and that they met those standards to be found consistent with the comprehensive plan.
Okay, we have a motion.
I'll second.
Okay, we have a motion by Commissioner Spies and a second by Commissioner Stranahan that the amendment is consistent with the comprehensive plan. Is there any further discussion? Hearing none, I'll ask Miguel for the roll voice vote.
Commissioner Boycourt,
No.
Commissioner Stranahan,
Aye.
Commissioner Gezzi,
No,
Commissioner Spees,
Aye.
Chairman Council.
Aye.
That motion passes 3-2.
Again, motion carries 3-2. Thank you very much. At this time, I'd entertain a motion to adjourn our Planning Commission meeting.
So moved.
Okay.
Second.
We have a motion by Commissioner Spies, a second by Commissioner Stranahan to adjourn at 10:50. Miguel, would you call the vote again?
Sure. Commissioner Boycourt,
Aye.
Commissioner Stranahan,
Aye.
Commissioner Gezzi,
I
Commissioner Spees,
Aye.
Chairman Council.
Aye.
Motion passes.
Meeting is adjourned. Thank you very much for your time and patience.